Good afternoon, everyone. My name is Dylan Minch, and I am the Legal Representation Director at the Texas Children's Commission. On behalf of the Children's Commission, I would like to welcome everyone today to today's webinar entitled Understanding the Federal Intersection with Key Texas Child Welfare Laws. This presentation will be provided by Allison Green, Legal Director of the National Association of Counsel for Children, and Kellie Price, Special Projects Attorney at the Texas Department of Family and Protective Services. It will focus on the intersection between federal and state child welfare laws. A copy of the PDF of the PowerPoint presentation, along with any additional materials by the presenters, will be made available for download on the Children's Commission On-Demand Training and MCLE webpage. For those watching this presentation live, the Q&A feature is available for this webinar, and all questions will be addressed at the end of the presentation if time allows. Additionally, the MCLE course number will also be provided at the end of the presentation. If you happen to be watching this webinar on replay, you can email cctraining@txcourts.gov for MCLE self-reporting presentation. It is now my pleasure to turn this presentation over to our two co-presenters, Allison and Kellie.
Thank you, Dylan, and thank you for inviting us to be with you all today. Hello, Texas. We're really excited about today's presentation, where we really are going to be talking about the intersection between the federal laws that create the structure around America's child welfare system, and then your Texas state-specific laws that give life to those federal laws, that implement them, and that shape what your daily practice looks like on behalf of children, families, and agencies. So just as a roadmap for kind of how the next 90 minutes will go, we are going to hit upon 6 key federal child welfare statutes. To be clear, that's not everything. There are more than 6 key federal child welfare statutes. We've chosen the 6 that we think are most salient to your daily practice, and that we really wanted to delve into. We felt there was a lot of learning could happen, but there are other ones that we will not hit on today. We will go back and forth between Kellie and myself. I'll be giving the federal overview, and then Kellie will be talking about the Texas interpretation of that. It's important to remember, and I'll say this at the outset, but I'll probably reiterate it throughout, that the federal government really provides the floor, the baseline of what states must do. But states can then from there choose to go above that, beyond that, or sometimes to not follow at all, but then to create their own system using their own money or their own policy. So we're going to talk about how that plays out. But the federal government basically provides a baseline that Texas might have its own nuances for. And then, as Dylan mentioned, we'll leave time for Q&A at the end. If questions come to mind that you don't want to forget while we're talking, please feel free to put them in the Q&A box on Zoom, and we will review them towards the end. Next slide, please. So I mentioned we'll be going over 6 federal laws, and they are listed here in chronological order. We're going to be starting with CAPTA, or the Child Abuse Prevention and Treatment Act, which is really one of the first federal efforts to create a more uniform child welfare system. Then we're going to be speeding along about 20 years and talking about ASPA, or the Adoption and Safe Families Act. Third, we'll touch on the Foster Care Independence Act. Fourth, the Fostering Connections to Success and Increasing Adoptions Act. 5, the Preventing Sex Trafficking and Strengthening Families Act. And then last, but certainly not least, we're going to be talking about the most recent federal reform, which is the Family First Prevention Services Act. Next slide. So what is this cartoon? The carrot and the stick. This is the visual that comes to mind for me when I think of child welfare law. Why? Because, as you all well know, child welfare courts are state courts. These are not federal courts. We're not talking about class action suits or anything like that. We are talking about family courts, which are state-run, governed by state dollars in their court system, governed by state statute. And because of kind of basic principles of federalism, the federal government is a bit inhibited on what it can mandate state courts to do and what it can mandate state agencies to do. Instead, like many other systems like education and healthcare and law enforcement, many others, the federal government uses the power of the purse, the almighty dollar, as a carrot and a stick. It develops programs and then says to states, hey, you can use this money, but there's some conditions attached if you want to take it. And sometimes those conditions are carrots. It says you get more money or bonuses if you do certain things. Sometimes those conditions are sticks. It says you will lose money. There will be disincentives if you don't do certain things. But in the end, when we think about federal child welfare legislation, we're really less talking about rights, because rights are embedded in state law and sometimes in federal constitutional law. We're more so talking about a financing scheme, a financing structure that then builds out what will happen on the state level. So that's what I think of when I think of these laws. And I just wanted to share that photo with that image with you before we jump into our first law, which is next slide. It is CAPTA, the Child Abuse Prevention and Treatment Act. Next slide, we're going to delve into it. Thank you, Dylan. So what is CAPTA? Well, this law really marks some of the first congressional federal involvement in child welfare. Earlier in the 1900s, there had been a White House summit on child welfare, which was really like the first national convening on the issue. But this was the first time Congress got involved. Why? Well, some of this was reactionary. In 1962, a very seminal publication came out by a pediatrician from Colorado, Dr. Henry Kemp. The article was called The Battered Child Syndrome. You all may have heard of this before, but it really served as a catalyst for public alarm, saying, oh, there are children, young children being harmed in homes. And the public's attention was really stoked by this. Congress felt like they had to do something to meet the moment and try to address this national interest or concern that child abuse was happening, and that it was widespread. Additionally, as Congress began to look at this, they saw a lack of uniformity between state systems. So they said, let's create a federal law that tries to create some consistency across jurisdictions. There was really a concern that one, children were being harmed in their homes, but two, that even after removal, nothing was being done to create meaningful case plans to try to either reunify them or try other permanency. You know, we're now, 50 years plus from CAPTA, and I think there's been some progress from it, but there's also been a lot of very justifiable critique. Immediately following CAPTA, there led to a dramatic increase in the US foster care population, something we're still trying to dial back from. So what does CAPTA say specifically? Next slide. Well, a few things. One, it requires states to have mandated reporting laws for hotlines where people can call in and share concerns. It is not specific about exactly how who must be a mandated reporter. States have deference about how to define that, but it does say every state must have a reporting scheme of some sort. It also does try to address prevention. It has what are called CBCAP funds, community-based prevention funds, which are some of the best opportunities to try to get funding upstream, and is one of the only streams available to parents and children who have not yet touched the Child Welfare Agency. Probably a lot of potential there to unlock in the future. CAPTA also has procedures for substance-affected infants and has protocols in it for an appointment of a representative for the child. So here we say appointment of a trained GAL, and that person does not have to be an attorney. In Texas, you all do require attorney or AAL appointment up until the time of PMC, permanent managing conservatorship. We would love to see that extended even beyond there, like about 37 other states who do so, but CAPTA does not require it. CAPTA also requires triage protocols. So it asks states or requires states who accept these funds to have some way of triaging their cases and creating differentiated responses based on the degree of severity alleged. There's some pieces in there about training professionals. Next slide, please. And also some baseline definitions of child abuse and neglect. This is, again, where like that federal floor comes in. Every state has definitions of what constitutes abuse or neglect. This is the only federal statutory definition we have in CAPTA, and it defines it as following: any recent act or failure to act on the part of a parent or caregiver which results in death, serious physical or emotional harm, sexual abuse or exploitation, or an act or failure to act which presents an imminent risk of harm. So kind of somewhat of a word salad there, but these are words that might be familiar to you: imminent risk, serious physical or emotional harm. There's definitely like it captures this essence of it should be serious for it to be quantified as abuse. But again, states have deference to further define it. CAPTA requires confidentiality of state child welfare agency records. It also is the mandate to have citizen review panels. You may be familiar with yours in Texas, but every state has these where public citizens review high profile or cases with fatalities in the state. CAPTA requires criminal background checks for foster parents, and it also requires procedures for identifying and assessing children who are known or suspected to be victims of sex trafficking. And that was a more recent update to it. So it kind of takes that abuse definition, but also says trafficked children are part of this definition. And that was part of Congress's effort to say, look, even if a removal doesn't happen, children who have experienced trafficking should be eligible for services by child welfare agencies. So now I'm going to turn over to Kellie to talk a little bit about how this has played out in Texas.
Thank you, Allison. And I'm just going to move some things on my screen. So when I was invited to present on this topic, I was both excited, as Allison said, but I was also dreading it a little bit. I was excited because I think it really is fundamentally important for practitioners to know when and why things are required. I think that it guides us so that we know when we have some flexibility in practice, but also when we lack that flexibility due to requirements that might be in statute or in rule. But I was also dreading it a little bit because who gets excited about black letter law, right? So I'm going to try to do my best to be engaging as we go through this very high level review of the Texas Family Code. So along those lines, as Allison moves through each of the federal provisions, please note that I did not include every single counterpart in Texas law, and that was mostly due to the time constraints. So turning first to CAPTA in Texas. So regarding the mandatory reporting requirement, you can find that in Texas Family Code 261-101. And the first thing that I'm going to do is try not to read the slides to you because they're mostly copied verbatim from the code, which you can find because I put the exact provisions there. So not reading the slide, but there is plenty of wordage up there for you to look at. While DFPS is limited in their investigation, those investigations are going to be limited to typically abuse or neglect that is by the person in a traditional caregiver role. So sometimes we refer to that as family-based investigations versus school investigations or childcare investigations. And would not necessarily investigate like an allegation that, for example, the neighbor abused the child if that neighbor was not providing care for the child, right? But the important thing to note is that the reporter doesn't need to know any of that. The statute tasks the reporter with just making the report. They do not need to know whether the abuse or neglect falls under DFPS's quote unquote jurisdiction or not. The other important thing to note is that for professionals, so if you meet the definition of professional, you cannot delegate the responsibility to report. So for example, if a teacher has reason to believe that a child has been abused or neglected, they can't go to the school counselor and say, hey, you make the report. The teacher, if they've got the cause to believe, then they're the one that has to do that reporting and they can't delegate it to someone else. And then also I wanted to note that while the identity of the reporter remains confidential, Texas did recently pass a law that prohibits DFPS statewide intake from accepting anonymous reports. And those are going to be reporters who just don't feel comfortable sharing who they are. DFPS statewide intake has to refer those calls to law enforcement. Now, CAPTA is one of our oldest provisions and has been implemented in Texas for decades. So this was actually formerly Texas Family Code 3401 and was added back in 1973, by the legislature in 1973, with an effective date of January 1st, 1974. Now, I don't have those dates and histories for everything, but where I do have them, I will share them with you. And we can go to the next one, Dylan. So the requirement for the appointment of a guardian ad litem, as Allison noted, Texas also mandates the appointment of an attorney ad litem for the child. And those provisions can also be found in Chapter 107. The guardian ad litem appointment is 107.011. And Allison, while you noted that it's not required after the PMC date, in my practice, I have noted that most courts do actually keep the attorney ad litem appointed until the child actually reaches permanency. So while it is an option that a lot of courts take advantage of. And what I've also seen frequently is that because the guardian ad litem does not have to be an attorney, I have seen the courts approach this in a couple of ways. So some courts will appoint the attorney ad litem, and then in many counties we have CASA. That is going to be our charitable organization with volunteer advocates. That is the main one that we have here in Texas. And then they would appoint the CASA as the guardian ad litem. And in some courts, I see they appoint the attorney in the dual role. And then if there is a CASA available, they appoint CASA as a volunteer advocate. And then sometimes there's not enough CASAs for each case, and the court might appoint a licensed attorney in the guardian ad litem role only in cases where the attorney ad litem has determined that what the child wants is at odds with what might be in the child's best interest. And we go to the next slide. Now, regarding the definitions of abuse and neglect in Texas, these can be found at Texas Family Code 261-001. And the thing that I want to note here is that actual injury or harm to the child is not required. So like Allison had indicated, that risk of injury, right? So here in Texas, we say the genuine threat of injury. Now, an example that I want to give, so if injury is not actually required, then how does this work? And I want to go into my pop culture reference here for a second. So in the 2000s, I watched a show called Arrested Development that I thought was hilarious. And in one episode, the mother, Lucille Bluth, is being driven absolutely crazy by her adult son, Buster's incessant and very loud snoring. Now, what I'm about to say is graphic. And of course, if you remember the scene, you might think it's hilarious, but as I describe it, it's going to sound terrible. So driven to her breaking point at this incessant snoring, she goes into his room with a baseball bat and starts beating what she thinks is her adult son, only to move the covers and find out that it was not him. He had made it look like he was in the bed because he had snuck out and didn't want her to know and had a recording playing. And so after she realizes that she did not, in fact, beat her son with a bat, she says, freebie. And the reason I point to that example is because that's not how it would work in Texas. If a parent did an intentional act toward their child, for example, intentionally shoves their child down a flight of stairs, and that child makes it to the bottom of the staircase and miraculously is unharmed, that is not a freebie in Texas. That is still going to meet that definition of abuse because it is an act that presents that genuine threat of physical injury that could result in substantial harm. Now, another little thing that I want to point out here is that the difference between abuse and neglect is that while the definition of abuse is an act or omission by simply a person, when we look at the definition of neglect, we're looking at a person responsible for the child's care, custody, or welfare. So in other words, you cannot neglect a child that you're not responsible for in the first place. Now, exploitation is that definition is looking at typically like a volunteer or an employee of maybe a facility or a program where the child is. Otherwise, similar acts of exploitation may fall instead under labor trafficking if it's not in that like facility situation. And that is the notes that I have for definitions, and I'll turn it back over to Allison for ASFA.
Thanks, Kelly. Okay, so now we're going to zoom ahead about 20 years. And another analogy that I use a lot when I think about federal law is the pendulum. You think of a pendulum in an old grandfather clock going from one side to another. And that's what we see federal leaders doing over the decades in child welfare. We see sometimes the system become very protectionistic of children's rights, lean into removals a little bit more, and then we see it swing back the other way towards a focus on family preservation and families' rights, and then we see it swing back again the other way. That's a trend over the decades. And we see that pendulum swing here between CAPTA and ASFA. ASFA was passed in 1997. So you need to put it in the context of the time period. This was a tough on crime time. There was a concern about prolonged stays in foster care. That new data had come out showing that young people were languishing in care for many, many years, and that not only were they languishing and staying there, but they were having great rates of placement instability. It was called foster care drift. And so Congress felt the need to act to become more restrictive, frankly, on and there was more of a focus on trying to achieve permanency for young people. To do that, Congress created new requirements, new case plan requirements, and providing more mandates on agencies about what had to be in a case plan to make it acceptable. It also required permanency hearings, at least annually, saying, hey, states, if you're going to do this, there needs to be court review to make sure children's cases are moving along and moving forward. It also allowed concurrent planning explicitly. And so think about why that is. If children have a permanency goal of reunification, that parent may have fits and starts making progress. Here, Congress was explicit to say, states can do a concurrent plan too, because we don't want things to just be starting fresh if the parent is not able to reunify. We want to have something in the works as a backup. ASFA also provides foster parents some new rights, the right to notice and opportunity to be heard in a hearing. This is not the same as standing or party status, but again, you can kind of see the same philosophy coming through here, that they wanted backups or alternative permanency options. And then ASFA included adoption incentive awards to states. So you can see as a package, like this is growing more towards that adoption end of things. States are allowed to be more restrictive than ASFA, but not less restrictive. The federal government also published rules, regulations implementing ASFA about 3 years later. So when you want to look to what the federal confines are of ASFA, you're going to want to look to the statute, but also to those implementing regulations that go through it in greater detail. Next slide, please. ASFA also provided slight modifications to the state reasonable efforts requirement. Of course, we know states are mandated to make reasonable efforts to preserve a family before executing a removal and to try to reunify that family if a removal has occurred. The language was tweaked to say that that is still a mandate, but that the child's, quote, health and safety shall be, quote, paramount. So you say, like, you just see this push and pull between the language. Probably most notably and most memorably, ASFA put new confines on states around termination of parental rights petitions. Overall, with exceptions that we'll go into, federal law under ASFA requires state agencies who are recipients of Title 40 dollars to file petitions to terminate rights if a child has been in care 15 out of the last 22 months. So a couple of things here. One, the federal government does not dictate how the courts must rule on those petitions, right? Like this goes back to federalism. The U.S. Children's Bureau only has power, Congress only has power over the recipient of that money, which is the Child Welfare Agency. Judicial officers still have full authority to review those petitions and should, and weigh, hear from witnesses, take evidence, and then make sound decisions to rule for or against a TPR. But I note that because I've seen that as a confusion in state practice, where sometimes judicial officers are confused and they think that they have to rule to grant a TPR if it's been 15 out of 22 months, and that is not the case. The only thing ASFA does is require agencies to make that filing at that time. And there's also exceptions to that. There are several exceptions in the rule, which you may be familiar with. For example, if the child is in a relative placement, the TPR requirement does not apply, or if the agency has documented a compelling reason that the TPR would not be in the child's best interest. So some things to think about. ASFA also creates places in the law where states can circumvent the reasonable efforts requirement. We call these aggravated circumstances, where they can move immediately towards a termination of parental rights if certain things have occurred. These are rare, but frankly, more serious or even heinous acts, such as homicide of a sibling child in the same home. Those are rare exceptions. We want to definitely see those used only as exceptions and not the rule. The federal government here, as in other places, allows states to define what those aggravated circumstances are for themselves. Overall, you'll see this shift that shows trying to make the system move at a quicker pace, at a faster pace, and to a slightly more regimented pace through these case plans and review of the case plans, which should include services, placements, and independent living programs for older youth at regular permanency hearing intervals. So that is what ASFA requires at the federal level, and I will turn it over to Kellie to detail how this looks in Texas.
Thank you, Allison. And Dylan, we can go ahead and move to the next one and talk about the paramount concern provision, which is found in Texas Family Code 261-001. And you can see that it is almost verbatim as Allison was talking about it in the federal provisions. This was added back in 1995 and then amended in 1999 by HB 3838 and was effective September 199. Now, when I talk to agency attorneys about reasonable efforts, I always remind them that reasonable efforts is not a compound noun, but reasonable is an adjective that modifies the term efforts. And when we're determining whether an effort is reasonable, that effort has to be consistent with the circumstances and providing for child safety, as it's described later in Chapter 262. And I think that this statute is reinforcing that interpretation and reminding us that the child's health and safety is the paramount concern. So in other words, if the effort does not provide for the child's safety, then it's likely not going to be a reasonable thing to do. And then if you could move to the next one, Dylan, thank you. Now, regarding the filing for termination of parental rights, this is actually an aspect of ASFA that we really don't grapple with much in Texas. Now, as Allison had indicated, ASFA is allowed that the states can be more restrictive, but not less restrictive. So here in Texas, due to our 1-year dismissal date deadline that's imposed under Chapter 263, typically in Texas, the original petition that's filed by DFPS is typically going to ask for DFPS to take possession of the child, to appoint DFPS as the temporary managing conservator of the child, and then pleading for termination of parental rights if reasonable efforts to reunify are ultimately unsuccessful. Now, even in jurisdictions that may not regularly plead for termination in the original petition, because of that 12-month dismissal date deadline that we have, and the automatic dismissal that takes place afterwards, even any amended petition that's going to take place in the TMC phase of a case, though that adds the termination grounds at that time, even those are still going to be filed well before that 15-month mark. So this is that 15 of 22 is not something that we deal with a lot in Texas because of the overall statutory scheme that we operate under. Dylan, if you could move to the next slide. Now, regarding aggravated circumstances, this can be found in Texas Family Code 262-2015. And this has some interesting history and is another good reminder of that flexibility that states have in implementing the federal child welfare laws. So this was originally added by Senate Bill 359 back in the 75th regular session in 1997. But it did not use at that time the language aggravated circumstances. It didn't use that terminology. And at the time, it was limited to serious injury or sexual abuse, and then the conduct that met certain penal code definitions, and that was it. That was all that had. Now then, later in 1999, this got amended by House Bill 3838, and it changed to using the aggravated circumstances language, and it added in some additional circumstances that could qualify, including certain types of abandonment. And the interesting part was they also added a prior termination of parental rights for under the endangerment grounds, which in Texas we typically refer to them by their alphabet letters, and so that's your D and E grounds. And then later after that, there was a provision for aggravated circumstances finding for any prior termination, involuntary termination of parental rights, no matter which grounds it fell under. And now those two, the prior aggravated circumstances for prior termination of parental rights, were then removed in 2021 in the 87th regular session. So that kind of shows that the, like Allison talked about with the pendulum, that pendulum sometimes happens here in Texas as well, and that the states have that flexibility to make those changes as necessary. Dylan, we can move to the next one. Regarding the detailed case plan requirements, my experience in Texas is that we actually don't typically use the term case plan. We typically talk about the service plan, right? So in court, when we talk about the service plan, we're talking about the family plan of service. And while the family plan of service, and which this can be found in Texas Family Code 263.102, and it has lots of provisions regarding the family plan of service. And this does include information regarding the child's needs and other details that can be found in that statute. But most of that focus around that is on the services that are being provided to the parents, as well as it also includes placement. It also includes the child's permanency goal. Now, the TAC rules do go into much more detail regarding the child's plan of service. And that can be found at 40 TAC 700. That's a lot of numbers when we get into the TAC rules, so I'm not going to read the numbers to you. But it can also be found in policy, in DFPS policy. And so you're going to be talking about, whenever I refer to policy, we talk about the CPS handbook. It is available on the public website. And that is going to be CPS handbook number 6241, which also goes into detail about what the caseworker has to do regarding the child's plan of service. So while we don't talk about case plan with that terminology in Texas a lot, and there may be pockets of, Texas is a big place, there may be pockets and regions in which that is the terminology that they use, know that when we're saying case plan, we're talking about the family plan of service and the child's plan of service. We can go to the next slide, Dylan. Thank you. Regarding the least restrictive environment, this can be found in the Family Code at 263.001. And the thing to note here is that for the most part, when we're talking about the least restrictive, we're talking about the most family-like setting. And so if the child is over 6 and there's no relative placement available, then that least restrictive setting is going to be a foster home or a general residential operation that's operating as a cottage home. And a cottage home is like when you have what they get licensed under is a cottage home operation. And so that is like each home has a house parent, and then each home is caring for no more than 6 children. And so it's trying to look more family-like, even though it's in that larger general residential operation when it has those smaller subunits within it. Now, if the child is younger than 6 and there's no relative placement available, then the preference is really for that foster home, and we're only looking at that cottage home if the department has determined that a cottage home placement is in that child's best interest. So that's where we talk about our least restrictive environment in the family code. We can go to the next one. The concurrent planning is in 2 different main spots in the family code. The first is 263-102. And so this is explicitly requiring DFPS to provide those concurrent services, family reunification services, and the adoption, promotion, and support services, because just like Allison said, we don't want to be going towards family reunification only, and then at the 11th hour, it doesn't work out, and we haven't done any work to try to achieve permanency. We're starting over for the child, right? So in Texas law, in that TMC phase of the case, the department is required to provide both of those types of services concurrently, and that's regardless of whatever the child's primary permanency goal happens to be. Now, if we move down to 263-3025, that's where you're going to see the requirement that the child's permanency plan include those those current permanency goals, which is going to consist of their primary permanency goal and at least one other alternate permanency goal. And if you go further into DFPS policy, it states that the initial primary permanency goal for every child entering substitute care should be family reunification, unless we have that finding of aggravated circumstances that we talked about before. And I thought I was going to turn it over to Allison, but I got one more slide, Dylan, for the next one. So regarding permanency plans and the APLA, the Another Planned Permanent Living Arrangement, those provisions can be found at 263-3026. And so that includes what the permanency goals can be. It includes the following goals. But when we get to the APLA goal, if that is going to be the permanency goal for the child, DFPS has to document a compelling reason why the other more preferable goals are not in the child's best interest. And that determination that APLA is going to be the child's permanency goal then has to be revisited at each permanency hearing. And so with that, I am now going to turn it over to Allison for the next one.
Thank you, Kelly. Okay, so now we're going to move on to 1999's passage of the Foster Care Independence Act, more commonly known by the surname of the senator who championed it, by the Chafee Act. You all might be familiar with the nomenclature like Chafee Services, Chafee Lead. This act is where this all hails from. In 1999, Congress passed legislation really looking at older youth. So you can kind of see almost a logic or a story in the storytelling of federal child welfare history. ASFA had started getting very concerned about permanency and kids languishing in care. And then we get to the Chafee Act and it's like, okay, well, what about those older youth? What are we doing when kids do age out of care without finding permanency? This act applies to youth 14 and older who are in care, and to youth 16 and over who left foster care for adoption and guardianship. So let's just pause to think that through a second. It kind of means 2 things. One, independence planning for a successful adulthood should start early. The federal government wants it to start by 14. The federal government does not want teams to start wrapping around a young person at 17 and a half years old, right before they, start thinking about adulthood and say, hey, what's your plan? It should begin early at 14 years old. But then there's this second provision that says, okay, but if a youth has achieved permanency in another way, they can still be eligible for these services if they were adopted or achieved permanency through guardianship after 16. Why is that? It's to eliminate a potential disincentive. What they did not want is older youth who might have a permanency option through guardianship or adoption to turn to their caregivers and have to face the difficult decision of well, we have this guardianship that could really work and get me out of care, but I don't want to lose access to these awesome Chafee funds and services. So Congress kind of saw that as a potential disincentive and said, nope, we're going to allow these so that you can get permanency and get the services too. We don't want to set up that like false choice for people. So what are the services that are offered? Well, first, it creates the Education and Training Voucher Program, or otherwise known as ETV. This is essentially a voucher that can be used up to $5,000 per year per youth, and it can be used to fund educational opportunities, training opportunities, tuition to programs, anything from college to vocational programs to textbook or supplies that are needed for those programs, up to age 26, which is pretty cool because you can, sometimes education takes that long to use. Next slide, please. It also, next slide, please. Sorry, yeah. It also established independent living programs, or ILPs, another term that many of you are probably familiar with. But importantly, it clarified that even if a young person is placed in an ILP residential setting or receiving ILP services, things like how to do finance and budgeting, life skills, all that stuff, that it does not mean to stop looking for permanency. Again, we see an emphasis on concurrent planning. A youth can be placed in ILP or receiving ILP services with concurrent efforts to still find an adoptive family, to still reunify, to still achieve guardianship. Additionally, Chafee has some important provisions about health insurance in it. It provided a state option to provide continued Medicaid coverage for young people who had left foster care up till age 21. Now, this was in 1999. About a decade and a half later, things changed a little bit after Congress passed the Affordable Care Act, which is not a child welfare law. But what did the Affordable Care Act do? Among other provisions, it allowed young people, not in foster care, but just young people nationwide, to remain on their parents' health insurance up till age 26. That was hailed as a very popular achievement, that there's a lot of public support for that provision. But lived experience advocates went back to Congress and were kind of like, well, what about us? Right? Thanks Affordable Care Act for doing that for our non-foster care peers. But what were we supposed to do if we aged out of foster care? We can only get it until 21. So later, Congress came back and remedied that by extending the state option to provide Medicaid up to age 26, so that there's parity between foster care and non-foster care youth. And then finally, in addition to the ETV funding, the Chafee Act also provides funding for housing, employment, counseling, really many other services to just kind of set up for stable adulthood. This is the act you want to be thinking about when you're thinking about reasonable efforts for older youth. The reasonable efforts mandate, which is housed under ASFA, which we talked about earlier, applies to all permanency goals. It, of course, applies to reunification. The states must make reasonable efforts to achieve reunification, but even if a young person has a different permanency goal, states must be making reasonable efforts to achieve it. What are the efforts to achieve guardianship? What are the efforts to achieve adoption? But what if a young person's goal or their permanency goal is what we call APLA? I don't know what it's called in Texas, aging out, emancipation. There's different terms, but what if that's the goal? Reasonable efforts still must be made to achieve that goal. So the practitioner should ask themselves, what would be reasonable in this circumstance to help ready this young person for a smooth transition out of foster care and into adulthood? And probably the starting point for that answer is the Chafee Act. It's reasonable to use these services like the education and training vouchers, ILP programs, counseling, employment services. The federal government has put them all out here. It's reasonable to use them. This should be the starting point for your reasonable efforts advocacy for older youth. And I will turn it over to Kellie for explanation of how this plays out in Texas.
Thank you, Allison. So this is a good time to do the reminder that since the federal law is the power of the purse, a lot of times the requirements are for the state's plan to include the provisions. And so just because the state's plan includes the provisions That doesn't mean that the provisions always make their way ultimately to the family code itself. And so for the Chafee Act in particular, this is going to be a place where you're going to find probably a lot more information on the DFPS website and in DFPS policy to look for that implementation in Texas. Now, DFPS provides the Chafee foster care independence services through its transitional living services program. So that's what we call it in Texas. And I dropped a link on the slide to the website, the DFPS website, that has lots of information for the public on just an overview of what these transitional services look like. They are available to youth ages 14 to 23, and they include things like circles of support. So what's a circle of support? So they're youth-led and youth-focused. The youth is able to invite participants from all kinds of areas of the youth's life. So that could be their siblings, birth family members, foster or kinship care providers, teachers, relatives, church members, friends, mentors, etc. And then the participants come together and they're going to develop and review the young person's transition plan that Allison talked about, that transition to independent living. And it's going to look at the youth's strengths, their hopes, their dreams, their goals, and then what are their needs, especially in the areas of education, employment, health or mental health, housing, and then all of those PAL life skills training components, which comes to the next bullet point, which is preparation for adult living, or PAL in Texas. So in Texas, the youth is going to have their primary caseworker, who is the one that is trying to achieve the permanency with a relative or adoption, etc., all of those aspects. And then they also are assigned a PAL worker, who is going to be the one who is going to be that subject matter expert regarding all of these services and benefits that come from doing the PAL program. The PAL services include the Independent Living Skills Assessment and Training, support services for things like vocational training, GED preparation, college entrance exam preparation, driver education, counseling, volunteer, or mentoring by volunteers, etc. And then those PAL benefits include all kinds of things like the transitional living allowance, the case management services, and aftercare room and board assistance. In addition to the circles of support and the preparation for adult living program, there's also the education and training vouchers that Allison talked about. In Texas, we do have college tuition and fee waivers, and those are also widely available to youth who had been in care. And then we also do have the Medicaid coverage until age 26 here in Texas. So I do highly recommend visiting that link. I got to it with a quick Google search of Chafee and Texas, and it led me to that page. It had a lot of great information, and I do recommend if you want to do a deeper dive into that is a great place to start. I turn it back over to Allison now.
Thank you so much. Okay, so let's go next to the Fostering Connections to Success and Increasing Adoptions Act of 2008. What did this act do? Thinking of it very broadly, it introduced the idea of well-being as the third goal of the child welfare system. When I was trained as an early practitioner many years ago in this field, I was trained to think of child welfare as a triad: safety, permanency, well-being, safety, permanency, well-being. But it was really in 2008 that Congress said, well-being is a third and formal goal. We're not just focused on safety. We're not just focused on removals. We're not just focused on getting kids out of care. We have to think about the quality of their lives while they are in care too. And they did this in a few ways, thinking of well-being through several lenses: their health and mental health, their education, particularly their educational success and stability, and also their sibling connections. A lot of prior federal law, rightfully so, has focused on the parent-child relationship, incredibly important. However, when talking to lived experience experts who have gone through the system, many of them will say that, I kind of understood why I was separated from my parent, but it was the separation from my siblings that was equally or more painful from that than separation from my parent. And then so this is a really important law to look at when thinking of your client's well-being and the well-being of the children that you may oversee their cases or work on their cases. So a few things that it does. First, it permits states to expand foster care up to age 21. That is not an option that has been taken by all states, but it is taken by the majority of states, allowing those foster care services to continue. This kind of jives with what we know about adolescent development to begin with, that not many 18-year-olds are ready and able to just start fending for themselves when they are 18 and 1 day old. That extra 3 years has been shown to make a big difference in outcomes. So it's interesting because it's kind of a converse in the research. Research shows overall that foster care produces a lot of negative outcomes in terms of trauma and mental health and involvement later in the criminal legal system, poor academic standing. Like, the research is not great on the efficacy of foster care to begin with. However, the research also shows that once in foster care as an older youth, if you stay in for that extra 3 years, there's kind of an upturn. The outcomes get a little bit better by staying in and having that access to housing and stability and other support. So it's kind of a confusing thing, but that's what the studies show. So states can tie different requirements for youth to that extension in foster care in a way that they can't for youth under the age of legal majority, under age 18. So states have the option to say, we want to require a young person to be in a school or a work program or something like that. Although the federal government allows some exceptions. For example, if the young person has a disability or a medical condition, those requirements can be waived. Additionally, next slide, please. The Fostering Connections to Success and Increasing Adoption Act also brought forward kinship guardianship and kind of elevated it in a new way. We saw previously that emphasis on adoption subsidies and incentive grants through ASFA. Here, this is based on feedback from the field that sometimes guardianship was a much better fit for a young person than an adoption. And so states now can get subsidized and get a federal match for subsidized kinship guardianships in the same way as adoptions. In keeping with the prioritization of relatives, this law also requires states to conduct diligent search for relatives and notice to those relatives if a young person is removed within 30 days of that removal. So it should be early contact with relatives and just prioritizing placement with them wherever possible. It also provides that states must have licensing, but that non-safety related measures in those foster care licensing standards can be waived for relatives. So what do we think about when we think of like non-safety related? I get a little twisted on that because I'm like, why would we have a licensing regulation that was non-safety related to begin with, right? Shouldn't they all be about safety? But sometimes they're not. I formerly worked in a place where a neighboring jurisdiction had a law, I had a foster care regulation against bunk beds. I mean, that's a non-safety related, a child sleeping in a bunk bed. I think we can all hopefully agree bunk beds are like a generally safe thing. Lots of children out of foster care slept in bunk beds. But for some reason, in that neighboring state, their foster care regulations would not allow someone to be licensed if the child was going to sleep in a bunk bed. That would be an example of a non-safety related measure that could be waived at the discretion. Someone might say, hey, I have this great, wonderful grandma or auntie or uncle who's ready to take this kid, but the kid's going to sleep in a bunk bed. Who cares? Sounds great. Let's place this child there. And states have discretion to define what non-safety related means. So that's kind of overall what that 2008 Act does. It also, just to go back to the sibling piece a second, I just wanted to emphasize that it requires states to make reasonable efforts to try to place siblings together or to maintain visits between siblings if that placement is not possible. It's interesting because that is in the law, but earlier I mentioned the implementing regulations of ASFA, which is what requires court hearings to be held and court findings to be held on reasonable efforts to achieve permanency. Those are required to be in court findings. The sibling piece is a requirement on agencies, but it's not required for court review. That doesn't mean you can't advocate on it. You should talk about it. It's still a mandate that agencies are held to, but the mandate is not, it doesn't transfer to court review necessarily, but it is, agencies are beholden to it as Title IV grantees and recipients of that funding. They are required to make reasonable efforts to try to place siblings together, and if not possible, to facilitate visits between siblings placed separately. And now I'll pass it to Kellie.
Thank you. And we can go on to the next slide and jump right in to extended foster care. So the definition is going to be found in 263-601, and then the extended jurisdiction for the court piece is going to be found in the very next section in subsection 602. So I do actually want to point out that Texas had an extended foster care system for a number of years, although I couldn't find the exact year in which that was established. But it did further expand the program after the passage of the Fostering Connections Act of 2008 with some state legislation in 2009. So now, as Allison explained, the states are allowed to, and Texas has, there are stipulations for young adults before they can go into extended foster care, requiring that they have to be either attending school or working or both, or have that documented medical condition or disability that prevents those activities. And that is one of the things where I actually have seen instances where some advocates or maybe even some judges or members of the public sometimes don't understand that it's not automatic, and sometimes are upset that there are those requirements there, right? And so one of the other things that I've noted is that, so as Allison was explaining, we all know as practitioners, or hopefully we know that about that outcome that the research shows, that if the young adult, if the youth stays in foster care for that longer provisionary period, up to 21, that their outcomes tend to be better, and that's what the research shows. And so we know that as practitioners. So obviously we want our older youth who are aging out, we want them to stay in that extended care. But there is also the fact that a lot of youth don't want to be in foster care. And so when they become adults, they do have the same rights that any other adult in Texas would have. And they do have the autonomy to decide whether they want to go into the extended care program or not. And so sometimes I have also seen advocates struggle with the fact that we can't make a young adult stay in that extended foster care. But if you are an advocate for an older youth who is aging out, certainly, having these conversations with them about the importance and the benefits of staying in care. And I know it's hard because I've had young adults on my caseload who did not want to stay in care. And then, of course, making sure that we're working with them so that those who are eligible can stay in that program. We can move to the next slide. Now, fun fact, Texas uses the terms conservatorship and guardianship kind of opposite of a lot of other states. So the kinship permanent guardianship provisions, that in Texas is going to be called, that's when our kinship provider, our relative caregiver, is going to be appointed the child's permanent managing conservator. And so in Texas, we call this the Permanency Care Assistance Program. And this can be found in a couple of places in the Texas Family Code under 264-851 and some subsections after that. Here is where we're going to find that kinship provider definition. This is a relative of the foster child or another adult with a longstanding and significant relationship with the foster child before the child was placed in their home, which is going to cover our kin and what we call in Texas fictive kin. And then we're going to go to the TAC rules regarding the further requirements of the program in general. And so in the TAC rules, and that's going to be 40 TAC 700 and going with some subsections there. So that says that this kinship caregiver has to then be eligible for the receipt of foster care payments for 6 months. So what does that mean? It means they went through the licensing process, they got licensed as a foster parent, and then they had they retained that for 6 months while they're caring for the child, and those 6 months have to take place before the court makes that appointment of that caregiver as the child's permanent managing conservator. Now, this is another area where I have seen sometimes advocates get a little frustrated because it is limited. Like, there are these rules in place and the eligibility is limited. This is not something that the department can just choose to provide this funding for caregivers who are not meeting these qualifications. And so I know that sometimes that's frustrating, but I just want to point you all to the places where these requirements live. So again, that we know as practitioners, where do we have flexibility and where do we not have flexibility? And we can go to the next slide. So regarding the notice to relatives, both of these provisions in the Family Code were added back in 2011 in Senate Bill 993, back in the 82nd regular session. And so this does require that notification of the removal, and it is now relatives within the 4th degree of consanguinity. That's a relatively recent expansion from 3rd degree of consanguinity. So that expansion now is going to be reaching to include great-great-grandparents, great aunts and uncles, and first cousins of the child, adult first cousins of the child. And then in Texas, we also have the requirement to provide that notification of removal to adult relatives of the alleged father, if we have a reason to believe that he is indeed the biological father. And then the individuals who the parents list on the child care resource form. Now, in addition to the requirement on the agency to do the notification to the relatives, there is also the court oversight aspect of that can be found in 263-007. And so that is requiring DFPS to file a report regarding the notification of relatives with the court. And so there's actually a specific form that caseworkers can fill out, and that's going to talk about who have they contacted, who have they not been able to locate and contact, what efforts were made to do so, and essentially why they were unable to. And that report is going to be due 10 days prior to any of the hearings under Chapter 263, so like your status and your permanency hearings. We can go to the next slide. Now, regarding the waivers of the licensing rules for kinship caregivers, that's again a place where we're going to find those in the Texas Administrative Code. And so that's going to be in 2 different places. So the licensing aspect is actually covered in Texas by the Health and Human Services Commission. So they're in charge of like the minimum standards and the licensing, et cetera. And they take ownership of that part. So this TAC rule is going to be found in HHSC's rules. It's going to be 26 TAC 745, and I'm not going to read all those numbers after it. And that's going to govern what they call the waivers and variances of minimum standards, and that applies to all providers. And the reason why is found in DFPS TAC rule. And that's going to be 40 TAC 700.1035. And that's because Title 4E of the Federal Social Security Act requires that the state's child care licensing agency apply the same standards to relatives who choose to become a foster parent as it applies to non-relatives, with the exception that the licensing agency may, on that case-by-case basis, waive those non-safety related standards with respect to a relative child in care. Now, Allison talked about the bunk beds. An example that I've seen here in Texas is that sometimes the caregiver may not have enough bedrooms for all of the children. And so if it's grandma, for example, she may have the boys staying in a room in one of the bedrooms, and then the girls are staying in the bedroom with her, or perhaps the younger children under the age of 5 are in toddler beds that are in her room, and the older kids are in the other bedroom. And so those are things that I believe, and of course I'm not in HHSC and I'm not a subject matter expert when it comes to minimum standards, but that is one of the things that I recall one of my kinship workers making a statement that, oh, no, it's okay, this is a kinship home, so this is fine. And so that might be one of those non-safety regulations that a relative provider could ask for that waiver. We can go to the next slide. So as Allison said, the requirement for the agency to make reasonable efforts to keep siblings together, this is another provision that is going to be found in DFPS policy because it's not one of the things that requires the court oversight on. Now, again, that doesn't mean that you can't advocate for these things, but you should know where they live in the CPS handbook, and that is in policy number 4114.2. And so what this is requiring is the reasonable efforts to place the siblings together, again, unless it's contrary to their safety or well-being. Now, if they are not placed together, then there has to be that frequent visitation or interaction, again, unless it's contrary to their safety and well-being. And in situations in which the separation is not due to a safety or well-being issue, but instead is due to a lack of placement capacity, then that is going to require that higher levels of management be aware of this situation. So essentially, the program director has to approve of making this placement in those times of necessity because there's just not enough placements to place all the siblings together. Then at that point, your program director, or if you're in a community-based care area, your SSCC equivalent of a program director is going to have to be signing off on that decision. Now, regardless of whether the siblings are separated because of a safety issue or because of a placement capacity issue, that decision to separate them has to then be revisited before every court hearing. And we talked about earlier, we talked about where we can find information regarding the child's plan of service. So in situations where it is a safety issue, then the child's plan of service has to discuss what strategies are being used to address that, to make sure that those siblings can be reunited. So this is definitely an area where, even though it's not in the penal code, it is in detail within that DFPS policy. And that's the end of this batch of slides, and I'll turn it over to Allison.
Thank you. Thanks for sticking with us, audience. We have 2 more laws to go, and we are right on track. Next up is the Preventing Sex Trafficking and Strengthening Families Act. I think often the name of the act emphasizes sex trafficking, but that's actually one of the smaller provisions of it. And here's what the act does. I've boiled it down to 5 main things to remember about this statute. Number 1, it does mandate child welfare agencies to develop policies for identifying and responding to youth who are at risk of being trafficked. For example, it requires a meeting after a youth goes missing and has a meeting to address a plan for why that youth has gone missing and to try to put services in place. It certainly does look at trafficking and kind of it is a federal recognition that young people in foster care are at increased risk for trafficking and exploitation. And it also does a host of other things unrelated to youth who have been trafficked. So for example, children 14 and older have, it entitles them to have 2 adults that they can include in their own case planning team. That's really important. It kind of goes back to that like key age of 14 that you see coming up over and over again in federal law. 14 as, the time to start those older youth meetings. We also see 14 as the time that the courts must consult with youth about their own desires for their life and their case plan. So youth 14 and older, of course, should be invited to their case planning meetings, but can also bring 2 healthy adults from their own life to join those meetings. They also must be given information about their rights. So this is the law that required state child welfare agencies to develop booklets, pamphlets, documents of some sort that detail the rights that youth have, and caseworkers must provide those to young people. Additionally, this law made the goal of APLA or aging out impermissible for youth under 16 years old. So this is kind of interesting. Prior to this time, that goal could have been chosen for youth of any age. And now state courts may not create that as a goal for youth under 16. So it's kind of going towards that federal push to not give up on alternate permanency too early, to keep pushing, keep up trying to reunify, trying to find relatives, trying to find other healthy adults in the young person's life. And then finally, the Preventing Sex Trafficking and Strengthening Families Act also established the reasonable and prudent parent standard. It kind of brought out this the word normalcy, which comes up more and more in child welfare training and resources today. Like, what does normalcy mean? When we talk about it in child welfare, it really means that young people in foster care should have the experiences that non-foster care youth do. Being able to go on their school trips, go to prom, join a sports team. There had been a lot of feedback from the field, from practitioners, and of course from young people who had experienced foster care, that they were prevented from having these opportunities, largely because systems are like liability driven, right? And so they may want to do something, but a foster parent may say, well, I want to let you do that, but I don't know if I can. I'm not sure that I have the right. I'll give you a few examples. Sleepovers at a friend's house. That's like a very common example for a lot of communities. It's like a pretty normal thing. Kids have a sleepover party for the birthday. They invite classmates. And young people in foster care said, well, my foster mom wanted to let me go, but she didn't know that she could sign off on letting me sleep in another place. Another example, when I was working in the state of Missouri, I remember this coming up. There was a young person in foster care who was, I think, in grade school, like elementary school, or junior high, and he was on a baseball team. And at the conclusion of the baseball season, that team took a team photo, and he was excluded from that photo because the foster parent and the school were worried about the idea of photographing a child in foster care. And this wasn't a photo to identify this young person as being in foster care. It was just a team photo, but you can see how us as adults and us as members of a bureaucracy kind of get so bogged down in the liability concerns. So here the federal government is saying, let's be reasonable and prudent. Let's kind of calm down, cool the temperature, and give foster parents the deference to make parenting decisions as reasonable and prudent parents should. Let them to use their good judgment to decide, yeah, you can go on that field trip. You can go on that sleepover. You can be part of that school photo. And that's what the reasonable and prudent parent standard is all about. And I'll turn it over to Kellie to discuss the implementation of this law in Texas.
Thank you, Allison. And so I want to start with that reminder that the federal stuff is, again, we're talking about the floor, right? So there are different ways that the states, they have room to kind of do different things. And also a reminder that not every provision that I have talked about in detail, the Texas counterpart, because, for example, one of the things that Allison had talked about was the youth being able to include two people on their transition planning team. And in Texas, in our circles of support, they're not limited to just two. There is that ability to have more. So just a reminder that just because we're not bringing it up doesn't mean that it's not important. It just means that we didn't have time to talk about all of the things, right? So going to the policies to identify youth who have been or are at risk of being trafficked. So we're going to find this again in policy, right? So DFPS has policies that are pertaining both to the investigation of trafficking allegations, and then as well as providing services to youth who are confirmed or suspected victims of trafficking. And so these policies, and as Allison had stated, policies when a youth goes missing from care, that is exactly where the 6462 is going to live under that umbrella of when youth go missing from care. That's where you'll find this policy on the DFPS or the CPS handbook. And so these policies are typically including utilizing the Special Investigations Division, referral to law enforcement. If there is a multidisciplinary team, typically that is with the Children's Advocacy Center, if the community has one, following those protocols where they're applicable. And then documentation of, again, we're looking at that child's plan of service now that we know where to find that. the documentation of the child's needs that might stem from their victimization, and then documenting the trafficking event itself and impact. Impact is Texas's computer system that is where the child's entire file or the family's entire file is going to live in Impact. Impact is how the caseworker documents the file. And then we can go to the next slide. Now, regarding the rights of children in foster care, that requirement, so we have two names for it here in Texas. In the Texas Family Code, it's going to talk about the Foster Children's Bill of Rights. That's going to be at 263-008. And it is stating the overarching policy of the state to inform children in foster care of their rights as, and essentially enumerates a list of topics that if the child has rights under those topics, that the department is required to notify the child of their rights. Now, again, the federal requirements are the floor. And so in the federal law requires that it's for youth 14 and up. In Texas, in the CPS handbook 6420, the document, the pamphlet that Allison referenced, we call it the Rights of Children and Youth in Foster Care. And it requires DFPS to provide all children and youth with that document in like an age appropriate way. And then the caseworker must additionally review that document with the child and the caregiver at certain points in time throughout the case. We can go to the next slide. Regarding transition planning, this is another place where we're going to find this in policy. And so that transition planning, going back to all youth age 14 and older, is just that verbatim in the policy. And it requires that the caseworker develop and review the transition plan at certain set points in time throughout the case as set out in that policy. The next one. So regarding, so I've always called it APLA, Allison. I know you said that different states might call it different things. I've always said APLA because if I see letters that can be made into sounds, then that's what I do. So the restriction of APLA to ages 16 and up is also not going to be found in the family code. It's going to be found in policy, and that's going to be 6234.4. And so anytime a caseworker is setting APLA as the permanency goal, it is indicating that in and of itself that the child has to be age 16 or above. But in addition to limiting it to the youth 16 and above, Texas has also put some other limitations on it. So again, this is not a set it and forget it situation. If the child has a permanency goal of APLA, DFPS has to have documented that it explored and ruled out the preferred permanency goals of family reunification, adoption, PMC, etc. And that there's a compelling reason why those are not appropriate or in the youth's best interest. And then it has to be revisited at each of those permanency hearings. And the safe and permanent living situation towards which DFPS is working and the services are directed is typically either going to be independent living or assisted community placement. And in Texas, this is typically what we're looking at as a guardianship. And then they also have to document that these two options that are usually the ones we're looking at in these cases are in the youth's best interest and can meet their long-term needs. So there's a lot of, if this is going to be the child's permanency plan, there's a lot of documentation and thought that is required behind this. And I think that is because, again, the preference is to move children to positive permanency so that in a home situation, in a family-like situation, that they know that they can call their family and that that's their home. And that in these cases where aging out or moving towards independent living is going to be a situation that we're giving a lot of thought and a lot of planning and scaffolding towards that for the youth. We'll go to the next slide. So the reasonable and prudent parent standard is going to be found in a couple of places, all in chapter 264. So I listed the first one, which has like kind of the overall definition. And just I had essentially the same notes and a lot of the same examples that Allison had as to what are we talking about? What is normalcy, right? And so essentially we're talking about things for foster children to be able to do the things that children who are not in foster care just normally get to do. And so the examples that I had were scouting, sports. Also, I had sleepover parties and swim lessons, right? So like swimming, because swimming can be inherently a scary activity, particularly for children who don't know how to swim. That was one where a lot of foster parents might be like, oh, I want to put them in swim lessons, but what happens if they get hurt? And so what we don't want is caregivers to deny foster children the ability to participate in these activities out of fear that they're going to be held liable if the child gets hurt climbing a tree at Girl Scout camp in the summer, right? So this reasonable and prudent parent standard is going to be applied to ensure immunity from liability. That's going to be in 264.114. Which provides the caregiver immunity from liability and prevents DFPS from taking adverse actions against a caregiver who approves normalcy activities, as long as they fall under this definition in the slide above. And then under 264.125, this requires DFPS to use its best efforts to normalize the lives of children in foster care by allowing their substitute caregivers without the department's prior approval to make the decisions that would allow the child to participate in the normalcy activities and using this reasonable and prudent parent standard. And that leads us to the last one. Allison, I'm going to turn it back over to you.
Sure. So last but not least, we have the most recent federal effort, which is the Family First Prevention Services Act. I'm sure you've heard about this in your states. And basically, Family First has four main goals: to safely reduce the foster care population by providing upfront preventative services when a child is removed, to promote kinship involvement, and reduce the over-reliance on institutional facilities, and then to support transition age youth. Specifically, Family First opens up federal matching funding for the first time for prevention services. This is like a pretty big shift for the federal government that traditionally only matched state dollars once a child was removed. And we could do a whole training on this, but it's important to know the money is available and awesome, and it's a great opportunity, but it's also not expansive. It's for three main categories: mental health, parenting classes, and substance abuse. And it's for services that have been approved by a national clearinghouse that are evidence-based. Congress did this because they really want these dollars invested where studies are showing that they make a difference. Additionally, Congress tied receipt of those funds to new restrictions on institutional placements, now known as qualified residential QRTPs, qualified residential treatment programs, and put a host of new restrictions on these placements in order to receive funding. We can talk more about how that's being implemented in Texas, but those two pieces kind of go hand in hand. Additionally, Congress created new regional partnership grants to fund recruitment of foster parents, and also established kinship navigator programs. They said, look, the idea is to prevent foster care to begin with. That's why we're providing more upstream services. But if a child has to come in, we're also reducing the amount of institutional or congregate care space available. So where are young people supposed to go? They said, we're going to invest in helping more kin get licensed through these programs. Kinship navigator programs really provide an ally or a partner for kin to help get licensed, maybe do legal work that they need to, to be part of the case, maybe to access public benefits. And then finally, for older youth, the Family First Act extends those CHAFE services we talked about to 23 years old, and then extends the ETV funds up to 26. And I'll turn it over to Kellie to talk about Family First in Texas.
Thank you, Allison. So there are a couple of places in the family code where you can find some of these provisions. And so the first one is the court review of those QRTP placements. Now in Texas, we have both what we call RTCs, and then now we have this discussion of QRTP. So an RTC is a residential treatment center, and a QRTP is that qualified residential treatment program. And you can actually go to HHSC's website, which is going to talk about the difference between those, as they are the licensing, the minimum standards, and they talk about all of those different things. Texas is still in the process of implementing a lot of these provisions. And so I was unable to confirm whether we have any QRTPs online at this moment. But my quick Google search of QRTP Texas landed me to the DFPS webpage that has all sorts of information about the QRTPs, including a list of frequently asked questions that talks about the difference between a QRTP and an RTC. And then also what would be required for an organization to be licensed as a QRTP, and then some of those minimum standards, and then also a request for proposals, et cetera. All of that information can be found on that web page, which I didn't put the link in, but again, I just Googled QRTP Texas and got to that page. And we go to the next slide. The requirement to provide documents to youth is in the family code already, and that's going to be in three main spots. The first is going to be the sections of the family code that govern permanency hearings before final order, and then the permanency hearings after final order. Now, both require that for any youth with an APLA permanency goal to document whether the child that is age 16 or above has been provided a copy of their birth certificate, so security card, driver's license, or personal identification certificate, and then evidence that upon turning 18, they were provided the certified copies of these documents. Then if you go to Texas Family Code 264-121, it is also requiring DFPS to provide youth assistance in replacing lost documents. So there's those provisions as well. And go to the next slide. And spoiler alert, this is the last one, right? And so then we also have the Texas Family First pilot. So this is, as Allison was explaining, that there's a focus on prevention services. And so this Texas Family First pilot looks a little bit like the required participation statute that we have in Chapter 264, in which the child is not removed from the family's custody, the parent's custody, but services are provided typically through family-based safety services, or FBSS. So these are services that are being provided but the child has not come into foster care or the custody of the department. So it looks similar, but there are some notable differences between that required participation statute and the Texas Family First pilot. So this pilot launched in October of 2022 in regions 1, 2, 3 West, and 8B. And as of the information I received last week, we've had 137 families who have successfully completed the program and 126 families that are currently in the program. The services that are provided are those ones that Allison mentioned. They have to be those evidence-based services. And for this pilot program, those are typically provided in the home. The child remains in the same home as the parent or both the parents. That is specifically required in the statute. The types of cases that have been handled in the pilot have included substance abuse cases, mental health cases, domestic violence cases, and cases in which the inappropriate physical discipline may have crossed the line into physical abuse. Now, those evidence-based services are those support services that have been shown to be effective through research and studies to improve the outcomes for children and families. And that's one of the main key differences between the Family First pilot and the required participation and voluntary FBSS services that we have had in Texas previously. And that brings me to the end of my part and gets us to our Q&A session.
Well, Kellie, I want to thank you and Allison both for an excellent presentation. Unfortunately, we don't have time for Q&A because we filled exactly the amount of time we allotted for this presentation. But if you do have questions, feel free to email either Kellie or Allison at their email addresses that will be included in the PDF that you will get along with this presentation if you have any follow-up questions for them. I do want to thank everyone for participating in our presentation today, and on behalf of the Children's Commission, I really want to thank our panelists, Allison and Kellie, for a wonderful presentation. We really encourage everyone to submit those questions if you have them to Allison and Kellie directly, and that's it. I want to thank our presentations again and wish everyone a wonderful rest of your afternoon.